I want to welcome all of you joining us. My name is Miriam Mora. I'm the Managing Director of the Raoul Wallenberg Institute, and I want to thank you all for making the time to be here with us this afternoon. Welcome as well to our panelists and to the students here, particularly those taking our Ethnic and Religious Tolerance course. I also want to take this opportunity to thank the faculty and staff of the Wallenberg Institute, Jeffrey Weidlinger, who apologizes that he's unable to be here today, Joe Johnson, and Eleanor Camp for making this event run smoothly in spite of some last-minute changes, and also our student researcher, Sophie, who's in the hallway. A word about these last-minute changes. Due to mass flight cancellations, one of our speakers, Benjamin Berger, is joining us via Zoom instead of in person. I want to extend an additional thanks to the Union and Michigan media teams for scrambling to make this event possible, even at the last minute. And thank you in advance for your patience should we have any technical issues during this event. This institute is named in honor of Raoul Wallenberg, a U of M graduate from the class of 1935 who led the most successful rescue operation of Jews during the Holocaust, saving the lives of thousands of Hungarian Jews. The Institute, now in its second year, is dedicated to the study and promotion of ethnic and religious tolerance by fostering cross-cultural understanding, elevating civic discourse, and developing strategies to combat anti-Semitism, divisiveness, and discrimination. A key part of this mission is the Samantha Woll Dialogue Series. These moderated conversations invite scholars and practitioners to share their expertise with the campus community, to showcase diverse opinions and model open and respectful dialogue. Samantha Woll was a proud graduate of the University of Michigan, where she distinguished herself as a passionate community leader from the beginning. She was a committed grassroots organizer, spearheading advocacy programs and events focused on women's rights, fair trade, labor rights, civil rights, refugee rights, Israel, and more. During her time here, Sam served in the Michigan Student Assembly, contributed as a news and editorial staff writer to the Michigan Daily, and represented students as the University of Michigan's delegate to the Ann Arbor City Council. Her greatest impact, however, was felt through her unwavering dedication to building bridges across religious, ethnic, political, and community groups. In October of 2023, at the age of 40, Sam was tragically murdered in Detroit. At the time of her passing, she was serving as president of the Isaac Igre Downtown Synagogue, a revitalized Jewish congregation in the heart of Detroit. Sam's influence, however, extended well beyond her own faith. She used her remarkable ability to listen and unite individuals of diverse backgrounds and beliefs when she founded the Muslim Jewish Forum of Detroit in 2015. The Samantha Woll Dialogues carry forward her legacy by championing her values of tolerance, compassion, generosity, and humanity. Today's discussion, Should Religion Play a Role in the Law?, will examine how legal systems engage with religious beliefs and practices in pluralistic societies, and how recent Supreme Court decisions and executive actions affect the relationship between church and state. This work is more important than it's ever been, and nowhere is it more consequential than right here on our college campuses. Universities, and particularly public institutions like our own, have unique roles to fulfill, not only in educating and empowering the next generation, but in serving as a marketplace of ideas where diverse viewpoints and perspectives can be freely expressed, evaluated, and critiqued. I will take this opportunity, therefore, to remind you all that the university's deep commitment to freedom of expression does not extend to the right to substantially disrupt or interfere with the lawful speech of others. You all have index cards available at the check-in table, or later someone will come around. You can raise your hand to get them. And we encourage you to put your questions or comments on those cards, which we will collect after we've been in discussion for about a half an hour. You'll see Eleanor up here come around to collect those cards. And we'll read out those questions and answer them for the last segment of our discussion. So now I'd like to introduce our moderator, Professor Terrence McDonald. Terry is Arthur Thurnau Professor and Professor of History in the Department of History here at the University of Michigan. He's a prize-winning historian of the American City, has been a Guggenheim Fellow, a Fellow of the Michigan Humanities Institute, and a Senior Fellow in the Michigan Society of Fellows. From 2002 to 2013, he served as the Dean of LSA, and from 2013 to 2022, he was Director of the university's Bentley Historical Library. Lastly, he's also a member of the Executive Committee for the Raoul Wallenberg Institute. Joining him on stage is Winnie Sullivan, Provost Professor Emeritus of Religious Studies at Indiana University, Bloomington. She's the author of many books, including The Impossibility of Religious Freedom, Prison Religion, Faith-Based Reform and the Constitution, A Ministry of Presence, Chaplaincy, Spiritual Care, and the Law, and Church and State Cooperation, Construing Religion in U.S. Law. And joining us via Zoom, looming above our stage here, is Benjamin Berger. Dr. Berger is full professor at Osgoode Hall Law School. He's a member of the College of the Royal Society of Canada, held the York Research Chair in Pluralism and Public Law, and served as Associate Dean from 2015 to 2018. He served as law clerk to the Honorable Beverly McLaughlin, former Chief of Justice of Canada, and holds an LLM and JSD from Yale, where he studied as Fulbright Scholar. His areas of research and teaching specialization are law and religion, legal and social theory, criminal and constitutional law, and the law of evidence. He has published broadly in these fields and is the author and editor of multiple books. So please join me in welcoming all three of them virtually and on stage.
Thank you all for being here on this unseasonably cold day today. So making the trip is important. And of course, you're all here because this topic of religion and the law is obviously much on our minds today. It seems as if we're hearing something about it somewhere, at least in the United States, almost every day. And so clearly we're all interested in this topic. I want to say a couple of very brief introductory comments and we'll move right in. First of all, I wanted to mention to the students in the ethnicity and religion class that the previous readings from Kimlicka and Taylor may be relevant for this conversation today. So if you want to reflect on those or think about those readings when you think about formulating your questions, it might be a useful thing. Secondly, for everyone today, the importance of the two scholars who are with us today is the fact that their work is actually a remarkably significant but non-traditional way of looking at some of these topics, I think, for many of us. And one of the things they contribute, they put pressure on some concepts that we sort of take for granted in the normal conversation about these issues. For example, law, religion, secularism, multiculturalism. Our guests complicate almost every one of those topics as they think about the way that law and religion interact. And so again, as you think about formulating questions, one thing you want to be thinking about is, how are they putting pressure on those concepts? What does that mean to you? What would you like to have clarified as we talk about this more in the discussion time afterward? This is typified, by the way, in the person that I want to turn to next, Professor Sullivan, who has written a book, which you may have heard from Miriam, The Impossibility of Religious Freedom. That title is a tip-off to the fact that there's going to be some interesting points made in this book. And so I'd like to ask by kind of starting things in your case with kind of what do you mean by that, and what does that mean for your approach to these questions on the agenda today?
So thank you, Terry, and thank you all for coming today. And thank you on behalf of Ben. Ben and I are friends. We've known each other for a long time, and we're really disappointed that we're not able to be here together and talk with you because we've really had fun preparing for today and thinking about the Canadian-U.S. cross-border differences. And here we are separated by a border, and maybe a little later in the conversation, we'll talk a little bit about how the shutdown exemplifies in some ways the differences in legal and religious cultures between the two countries, even though they seem in many ways so much the same. The Impossibility of Religious Freedom is a provocative title. Sometimes so provocative, I think, that people miss what the book is about. But what it means in a nutshell is that laws protecting religious freedom require that there be some stability to the word religion. In other words, in order to protect someone's religious freedom, you have to be able to decide whether they're religious or not, whether the thing that they're doing that is prohibited by law is religious or not religious. This is just a matter of law. It's not, this is not an ideological problem, it's a legal problem, right? So as a matter of evidence, if you come to the court and you say, my religious freedom is being infringed upon, you have to be able to convince the court that what, in fact, you are being prohibited from is religious rather than something else, right? So that dividing line between religious and non-religious is fundamental to administering laws concerning religious freedom. So my book, I mean, I could talk about it more maybe a little bit later. It's about a very simple case in Florida, a case, and the case came in which Florida residents who had buried their relatives in a grave, in a cemetery in Boca Raton, Florida, had been told to remove the articles they put on the grave because the city said that they violated the requirements that the grave only have flat monuments that could be mowed over, right? And these families, these were not exotic little assemblages at all. These were South Florida Jews and Protestants and Catholics who had made little memorials to their family members. And they argued that the city's request that they remove these articles violated their religious freedom, which was then protected under a brand new law, the Religious Freedom Restoration Act, the Florida Religious Freedom Restoration Act. And in the end, the judge decided, kind of to his own surprise, that actually what these plaintiffs had done was not religion. It was what he came to call purely personal preference, because it was something that each family had decided on their own, and there was no law in each religion saying, you must put a vertical monument. Now, there's many things, obviously I've written a whole book about this, I don't want to talk about the whole case, but you see how counterintuitive that is. How can it be that what seems like ordinary American religion is in fact not protected? That was really the point of my book. And so I've come to then think about and be interested in what happens actually to religion with the rise of the modern rule of law, modern state secular law, how religion is managed in different contexts under the modern secular rule of law. And one of the conditions of this management is the instability of the word religion, the lack of clarity, the inability we have to agree on what counts as religion and what doesn't count as religion.
Great. Professor Berger, I'm going to ask you a similar question. So you've written a book called Law's Religion, but of course the argument in that is that a phenomenological approach to the question sort of suggests that religion isn't laws anyway. And I'm wondering how you started with that and what you mean by that and your approach to that question.
Mm-hmm. Well, thank you. Let me just first make sure you can hear me all right.
Yep.
And it's coming through just fine. Well, thanks so much, Terry, for doing this. And thank you to Jeff, Miriam, Eleanor. I can't see everyone in the room right now. I've got a really good view of Terry and Winnie, but so I wish I could see you, but I'm sorry I can't be there. And indeed, as someone that's lived my life in Canada, but sections of it in the United States, I think this was the first time I've been precluded from coming to the U.S. when I wanted to, and it was right in the midst of Winnie and I having conversations, which we've had over many years, motivated by this conversation that we're going to have here today about the ways in which Canada is different than the U.S. and how that works on axes of law, of religion. And so I have been thinking a lot about that, and maybe we'll have a chance to chat more about that. Terry, in a sense, Law's Religion is though not as well known, in a sense, a kind of companion thought to Winnie's, but from the other direction. That book was essentially about exactly the problem of this dividing line that has to be made between what is religion and what isn't religion in order for a constitutional legal order to implement things like religious freedom. And the argument in that book was that as you start to think about the ways in which religion never appears before the law naturally, if there was even such a thing. What appears before the law as religion is what the law imagines as religion. And its imagining, its rendering of religion is a product of things we don't often associate with legal thought. Visions of time, visions of space, visions of the human being, visions of deep value. And that as you start to understand constitutional rule of law as invested with these ideas of human communities, space, time, value, one of the things that starts to happen is, I think, probably a theme that will come out in our conversation today, which is law and religion get pushed together as not as far apart as we tend to imagine in our discourse in Canada, and I think very much in the US. And so in a way, the book was, as Winnie's was, in that book of Winnie's, about troubling exactly the ways in which we attempt, the different devices we use, and we use many, to attempt to wedge apart law and religion as philosophical phenomena. What is their character? How do we experience law and religion? And the argument is, surprisingly, not as differently as we might imagine. And as an experience, how do we imagine their relationship? And so part of that is thinking a bit differently about law. And I think I think one of the key points in much of the work I do, including outside that book, is to resist the temptation of allowing law to be the differentiating feature between state and religion. To treat law rather as something that is a common feature, that is a kind of common currency of many human structures and community structures. And so we have this temptation to view law, real law, in a very state-based formal fashion. And I think it's very normal. It's sort of what some have referred to as a folk conception of law. It's the law that you find in statutes, legislation, decisions issued by courts, binding because they have the force of a state behind them. But important to my work is to emphasize what a not only narrow but misleading conception of law that is. That in fact, if we look at how humans behave, kind of anthropologically, we find that all communities, all societies need ordering norms. They need rules to govern themselves by. You came in and arranged yourself in that room in a fashion that required norms and rules. And so the problem that we actually find is not, as one scholar has put it, is not gaps in law or uncertainty in law, but actually an abundance of law. That there's law everywhere in our modern lives. And so, there might be some instinct among you to think, okay, well, Ben is talking about like real law and kind of soft law, right? Law that, it's norms or it's ordering, but it's not law. Law has enforcement and has state behind it. But much of Winnie's work and some of mine has been exactly about showing how intricate, how detailed, how institutional, how procedural law as a dimension of religion is. And if you're tempted to view the capacity of the state, police, or enforcers to back the law as evidence of real law, as binding. In fact, you could think about it the other way, that it's a measure of the weakness of state law, that it requires this force to influence it. So just to kind of sum it up, I think, that book and much of the thinking is about trying to trouble the distinction, which I think we find in the question for today, between what is law on the one hand and religion on the other, and to think more about the way in which religion and law are dimensions of each, and I think that's kind of the heart of what that contribution was, Terry.
Thank you. I wonder if we could turn, before we think about some comparative questions, to the question then. So when you ask the question, should religion play a role in law? One way of thinking about your work is that they're inseparable, but another way of thinking about your work is they're just not the same thing at all. So I'm wondering how you answer that question, given on the basis of your work, Professor Sullivan.
Let me see if I understand what you're asking me. Whether religion and law are actually distinct. I think that you have to think about, for what purpose are you asking this question? In other words, if you want to understand how human communities have lived through space and time, you find that all human communities have law and they have religion. They have, and law and religion share the task, you might say, of how the community imagines what human beings are, who human beings are, how they're related to the cosmos, how a human community is formed, and how we should live together. Those are tasks for humans that both law and religion contribute to. And they both do that very specifically by creating categories to describe the world we live in. And this is something that both humans in religious groups do, and through religious texts and religious practices. They experiment with and change over time and communicate with one another about what is this human thing, what is important here. This is something that religions do, and it's also something that law does. And they do this together. They both tell stories about what it is to be human. There are narratives that accompany all legal systems, and there are narratives that accompany religious systems as well. And these stories often work together. And one of my favorite, and I don't mean this in a totally joking way, both law and religion specialize in imaginary beings. So law needs fictions like the state and the corporation in order to do its work. The human person, these are imagined beings that the law uses. And religion, too, uses imagined beings. So these are the ways in which I see, over time, religion and law very much embedded in one another. So if I look at a new situation, I expect to see a law story, and I expect to see a religion story, and I expect these stories to fit together. Always, everywhere. This is the most serious business that we do as humans, is imagining how to live together. And this is the work that religion and law does. It has come to be, as Ben was mentioning, that in the modern period, we have increasingly imagined a separation between the two. And that's one of the interesting things that both Ben and I have worked on, is that in trying to separate them, ironically, actually you spend more time together because you are constantly trying to draw this line, right? So that the work of maintaining, if you like, in the US context, the wall of separation between church and state, it requires constant work, constant tuck pointing, if you like, and whatever other work you imagine that walls require. And that's because these things are shifting realities. both the nature of religious life in the US and the nature of law. We could talk, should we shift now, Ben? I mean, I could talk a little bit about specifically how this works in the US, how this separation occurs, and then maybe Ben can talk a little bit about the Canadian history, which is very, very interestingly different. So before the drafting of the Constitution, what you have in the US before the Revolution in the space of the United States is, of course, many, many different religions and laws, right? Indigenous religions and indigenous laws, many different indigenous nations with different legal and religious systems that interact with one another over time. Those are present in this country. Soon there are Spanish and French and English Catholic ideas about religion and law and practices of religion and law that are coming into this space. And then there are many different kinds of Protestants. And I really want to emphasize the multiplicity of both law and religion in the US space, because I think there is a bit of a tendency right now to shrink these two entities into single stories, and that is not a faithful telling of what happened in the U.S. So, with the drafting of the Constitution, imagining then a really messy picture, right? We do have sort of 13 colonies. We have Spanish and French settlements in various places. We have a lot of different things going on here. And all of these religious and legal cultures that are present at the time of the framing of the Constitution have come from elsewhere. And in those elsewheres, those religions and laws were very embedded in local histories and geographies and long stories, but they come to the US deracinated, in a sense, uprooted from those stories and kind of floating free. And this is one of the distinctive aspects of American religion, that it is not embedded in many hundreds of years of history, the way religion and legal traditions are in other places. And in the formation of the United States in the Constitution, you have then two commitments made, one to protect the free exercise of religion, and the other prohibiting the establishment of religion. What's most interesting to me is the prohibition of establishment, because free exercise of religion, or the guarantee of freedom of religion, is everywhere in the world today. All countries protect religious freedom, and international law, of course, protects religious freedom. But what is very distinctive about the US is this refusal to establish religion, refusal to have any kind of explicit government management of religion. And so that, and the effects of that are hard to exaggerate, in the sense that we have a lot of religion, but we don't have a very good way for the government and religion to talk to one another. In most countries in the world, religious institutions and governmental institutions negotiate with each other. This is not always, easy or simple, but if you want to talk about these things, you know where to go. There's a Ministry of Religious Affairs. There's no Ministry of Religious Affairs in the US. Basically, it's DIY. And this is true of both religion and law. So I will just end with here. I want to turn to Ben and have you hear a little bit about the Canadian arrangement. But often in the US, you hear today, and for a long time, the assertion that what we have in the US and what we should properly have is a separation of church and state. Now, as you may know, of course, these words do not appear in the Constitution. There is no separation of church and state mandated in the Constitution. And my argument would be, and I'm happy to talk more about this, is that is because we We have no church and we have no state in the United States. And so we can't separate them. What we have is we have a lot of religious stuff and we have a lot of law and politics. And all of that is managed by we the people, not by a sovereign state, as in most nations. It's a bottom-up process, and it's an often messy one. But it is not always hostile or contentious. It's just messy.
Thank you. Ben, do you want to take up that question next? And the comparative dimension?
And thanks, yeah. And maybe I'll focus particularly on just trying to draw out the contrast with the Canadian story here. You know, I'm going to assume little by way of sort of the background knowledge on the constitutional and religious history in Canada, and so forgive me if that's not true for those of you in the room. But I think it probably a natural assumption. And I think one way of getting into it is by thinking about the question of entanglement of religion and law a little bit more, and coming back, Terry, to the question of, you know, why is the question that was posed for this not the intuitive question for me or for Winnie? And so the entanglement of the two can take a number of forms, and I'll talk about some Canadian features that come out from these modes of entanglement, of necessary imbrication of law and religion, the way they're sort of tiled together at all times. So one way that's true is that the formation of the state often, in many places in the world, works with and through religion in its foundations. And that's a Canadian story very much, and in ways that are profoundly different than what Winnie just established. So a couple of facts about how Canada shapes up in its constitution, and where religion plays a role in that. So, and we can talk more about just how different this is. And in fact, maybe I'll ask Winnie to just sort of reflect on what sounds so different in this from a US perspective. But one feature that's really important to keep in mind about Canada that came to mind as Winnie was speaking is you have to remember we've had a constitution since 1867. Constitutional documents earlier, but nothing like constitutional rights until 1982. And so no constitutional protection of freedom of religion, or for that matter, equality. We have bills of rights and other sorts of norms that work in Canadian law deeper than that, but no supreme rights in our Constitution until 1982. So most of the history of the country takes place under an old model of constitutions, which is that rights are not central. What's central are the relationships among the communities that make up that constitutional order. And it's interesting to look back on that foundation in 1867 and even before, that what we see is that the core work of nation building and of state building in Canada was a question about the relationship between two organized institutional religions and established religions in many respects. And so if you know anything about Canada and Canadian history, you'll think about there being this Quebec and rest of Canada, or English Canada, which today is expressed as a French-English division. But in its history, that's reasonably new. Its history was as a Catholic in Quebec and Anglican, so specifically Protestant in the form of Church of England, outside of Quebec. And so when you go back to the history of Canada in the Treaty of Paris, the main thing that establishes the relationship between the French crown and the British crown, the main thing that's handed over in 1763 is all of this territory to the British crown at the conclusion of those wars. And in exchange, what does the British crown give the French crown? an assurance that Roman Catholicism will carry on in Quebec. That's the fundamental exchange. We see that in the Quebec Act in the 1770s. And then in 1867, we get something that I take to be quite startling from an American perspective, which is that we have the formation of a constitution in 1867, Canada as we have it now, although it was smaller and other provinces were added, forms around things like this will be the executive and this will be parliament and these will be the division of powers between provinces and the federal government. But what the courts in a modern era, in the 1990s, said was that the central bargain, the central term, essential to Confederation, what the courts said in the 1996 case, the Supreme Court of Canada, said without this, Confederation would not have happened, was the assurance for Catholic schools in English Canada, state-funded, state-organized, Catholic schools in English Canada, in Ontario, and Protestant schools in Quebec. And so the very fabric of the country is put together between really three sets of religious / legal, right? Religious institutionalized, state as expressing itself through and around religion. What are the three? Roman Catholicism, Anglicanism, where the Queen of England at the time is the Queen of Canada. She's the head of the Anglican Church. She's also the Queen of Canada, and the King of Canada is the King, also the King of England today. So Anglican Church, Catholic Church, and the suppression of indigenous religion. And that's a feature that we should talk about a little bit later. Those three things are the raw material of the formation of the state. And so this is about established religion. It's about the constitutional order being indivisible from religious interests, religious formations. And so when I say the state law works through and it works with religion, this is actually a more common pattern in the world than the American pattern. I'll say one other thing, which is that it strikes me, and I think it has struck Winnie as we've prepared for our conversation today, that another way that law and religion are necessarily entangled is that the ways of thinking about law are influenced by the ways of thinking about religion. That religious imaginations, the experience of religion, the phenomenology of religion, how it feels to come to religion, influences also how we view other authority like law. And so, I have wondered whether with these two established, organized, highly institutional, hierarchical and legal orders of Anglicanism and Catholicism shaping our legal order, we then find a particular attitude to law in Canada. What is that attitude? The central norm in the Canadian Constitution is peace, order, good government. That's the phrase. And when Winnie and I were talking about, so as a Canadian coming to the US, what do I think about distinguishing in Canada? I think we obey lines, right? We stand in line. It's a sacred thing, standing in line. And so there's a certain attitude toward authority, to legality, and then one wonders whether the history in the US, the particular religious and legal history, has influenced the particular attitudes toward law that exist there. So maybe I'll leave it there as a starting point.
Maybe let me just say one thing, if
Sure.
that's okay.
Mm-hmm. Yeah.
So I think that what follows here from what Ben is saying, as you hear, is that Canada was initially an extension of the British Empire, right? And so that law and religion in English Canada was English law and English religion, and law and religion in French Canada was French law and French religion. We were founded as a revolutionary country, right? We rejected British law and British religion. So that left us really sort of in a new space without this kind of continuity. So you can describe Canada very much as a settler colony of the British Empire. You You can't really describe the US quite that way because of the revolutionary break, which forces both those who are going to invent law in the US, which is what's going to happen, and those who are going to invent religion in the US and the churches in the US do not have this kind of long institutional history to build on, but they have to invent this state by state, and then eventually with the Civil War and the growth of the federal power at the national level. But it's very much more dispersed and disaggregated kind of experience, both with the imported immigrant religion and law and with the indigenous communities of the US, which is also a difference from Canada.
So I wanted just to follow up on a point that you were suggesting earlier, and it's a comparative question too. So in the contemporary moment in America, when these questions about religion and the state come up and end up in the courts, it has a feeling of a contest or a conflict. There are clearly sides in these discussions. So it's not as if we're, and I'm not sure this is true in Canada in the same way, Ben, but here, there appears to be the sides. It feels like a zero sum when the Supreme Court does this or doesn't do that. For example, the thing that you've written about, the decision in Hobby Lobby, there clearly were sides on that sort of thing. So is it the case, how does that conflict, I mean, inevitably that conflict is in society, there's no doubt about it, as you pointed out exactly why. On the other hand, how is it that these become these conflictual symbolic kinds of losses and wins on different sides of this question of religious freedom in this country? And maybe in Canada too.
So I think that's an interesting question. I mean, there's a number of ways to answer it. When I was a lawyer, I was a litigator. Litigators are natural lovers of fights. I mean, I think there's something to be said that the American legal system, in a sense, is very much set up as an adversarial system. So there is a tendency to frame all questions, not just religion questions, as one or the other. And anybody who teaches in high schools or colleges knows that American students love when you set up a class as a court and you set up one side versus the other. This has a tendency to suggest, both in the classroom and as a legal matter, that there are only two sides, and one is going to be the winner, one's going to be the loser, which is a pretty impoverished way of thinking about most complicated matters, if you think of it. One of the other things that Ben and I talked about is, as Ben hinted, part of it was, in the new project that I'm working on now, I'm interested in this question of American lawlessness. And I think that it has both religious and legal roots. Religious roots in antinomianism, which is a theological movement in the 17th century in both England and the US. But there are other roots too, maybe most importantly, the unfinished business of a constitution which does not take account of the hundreds of thousands of people who are regarded as property. So the unfinished business of enslaved persons in the United States, which is then going to take, it's still taking time to work out, right, creates a kind of lawlessness about the entire American project, I would argue. I think that the contentiousness of religion cases, and I would argue also not just the contentiousness, but often the triviality of religion cases, are the product of our wanting to squabble about religion matters rather than to address the most serious issues we face as a society. So if you look in the US case at the predominant religion cases come up in schools, they come up in healthcare, and they come up in the criminal justice context. There's some other contexts as well. But if you wanted to name the top 3 issues that Americans, and I mean all Americans, you notice I'm not using culture wars language, I don't use it, but I think that all Americans need to face together is universal health care, free and excellent public education, and a fair and just criminal justice system. And of course, also a fair economic system. So I think that there's a way in which this zeal we have for arguing small points is sometimes a way we have of distracting ourselves from dealing with the most important ones.
Great. Ben, is that true in Canada too, that there's this sense of contest around these religious constitutional questions?
I mean, there is, but let me kind of try to draw a distinction within it. So a couple of things. Number one, part of that sense of conflict is a feature or an artifact of the adversarial system, and we have an adversarial system, and adjudication shapes things into that conflict in a lot of ways. It's an interesting thing to think about all the ways that the procedures and forms of law shape, I've talked about shape religion, but shape the way we understand disputes, shape the way we think about truth. So there is this adversarial sense. And so there are sides, but I think the interesting contrast is sides about what? What does it feel is at stake in these conflicts over religion, which are taking place in Canada and are taking place in the U.S.? And, I wonder, I have some intuition that what's happening in the U.S. and why the stakes feel so different in the American register, because we don't have the same sort of breakdown of our legislatures, we don't have the same breakdown of our executive, and for that matter, of the judiciary. The institutions look totally different right now. Is that in some sense what's at stake in Canada when there are these conflicts feels more to me like sides about what the public interest should be. And my impression in the US is that the conflict is whether or not there is a public interest in this. That is, whether or not this is a matter for government and law at all. Whereas most of the ways these are shaped in Canada tend to be about quite pitched, but conflicts about what we should think about what the public interest involves. So this question of the presence of and shape of a public good or of a public interest is, I think, more the differentiating factor. And let me add just one thing to talk about. Winnie raised race and where lawlessness arises out of that. The Canadian space of where the question of religion distracts or does damage to our historical crimes is in respect of Indigenous peoples in Canada. Only recently has there been litigation about Indigenous or American Indian would be how it's phrased in the US. In Canada, Indigenous religious freedom or freedom of religion for Indigenous peoples. And the sensation around those cases in Canada is a lot more like what Winnie describes in the US. That is, that in many respects, turning to religion is a turn away from the fundamental problems that have to be worked out in the historical relationship between Indigenous peoples and the Canadian state. Because that history is one of just the rawest form of colonial suppression. And we can talk more about how religion in those cases has been misleading, in my view. But I just want to mark that as another place where freedom of religion seems to be an ill fit to the kinds of problems that we have to face as a community here.
Great. I'm going to turn now to some questions from the audience. And of course, none of them are exactly softballs. So let me ask one. How, if at all, in each country does religion map onto multiculturalism?
So that's an interesting question. In a way, multiculturalism, I would say, is not an indigenous US term. We don't speak of multiculturalism. It's more of a Canadian term. Why don't you talk about that, Ben?
Yeah, it's a great question. So, I've wondered how much I think for those of you in the room that have been reading, it sounds like Taylor and Kimlicka, and the question of Canada's defined in some way by multiculturalism is going to be very present. There's a long association of Canada as a multicultural country, and as you grow up in Canadian public school, what's the story they teach us about multiculturalism, or taught us when I was going through public school? It's that Canada is a multicultural society, it's a mosaic. The United States is a melting pot, and that's the sort of curriculum that we were given. So how does multiculturalism interact with questions of religion? I think one interesting point to just note right out of the gate is that multiculturalism is not a rights-based concept in Canada. It's generated out of government policy. It has only a very shadowy existence in our Constitution. It really isn't present in a muscular way constitutionally. It doesn't have effective force of any particular form. And so what's its utility in the space of thinking about religion? I think it has some grip in a certain place and then it loses it in another. So where does it have some grip? Multiculturalism goes some way to thinking in Canada about a sort of recognition of pluralism, that there is a public good associated with tolerance towards various religious forms. And so multiculturalism translates in the court's jurisprudence, in the Supreme Court of Canada's decisions. Multiculturalism translates into a commitment to the toleration of various forms of religion. And so there's a kind of instinct to pluralism, a sense that difference is to be welcomed. But of course also in multiculturalism and in its kind of associated concept of tolerance, what you find are strong limits on what qualifies as being admissible into that multicultural terrain and tolerable. And so, I think what we find in Canada is a fairly robust public presence of religious symbols and religious forms. Not in Quebec right now. That's an interesting story we could talk about. Bans on religious symbols going to the Supreme Court of Canada. Legislation in Quebec that purports to ban state officials from wearing certain kinds of religious symbols. But multiculturalism is an expression of a desire for a kind of pluralism in religion. But I think what's interesting in Canada is that the court has moved away from that language, is that the court no longer speaks in terms of multiculturalism as the core principle for religious freedom. It talks instead about neutrality, that neutrality has become the core norm for religion. So, I think there's some mapping. It's a good question. It kind of expresses a desire for the presence of religion in the Canadian space, but it doesn't have a sort of legal life in the case law in Canada.
Maybe I will just add on to that question, that the answer to that question, to contrast in the US, in some ways, the sort of zero-sum game of rights-based claims at the Supreme Court level tends to give the impression that we have this kind of contentious, always hostile, always sort of battling over religious rights and space for religion Whereas I think that if you look at what's sometimes called popular constitutionalism, that is the constitution that exists among people that is not in the courts, you actually have a very different experience. And I wonder if I can tell you a quick story about the US, which is a very positive story, which I think we all need these days. So the man who just is the new mayor-elect of New York, Zoran Mamdani, his father, Mahmoud Mamdani, is a professor at Columbia, as you may know, and he was a foreign student here, right, in the 50s or 60s, I can't remember exactly when. He went to the University of Pittsburgh. So this is Zoran Mamdani's father. His father grew up in Uganda and came to the US as a foreign student and went to the University of Pittsburgh. While he was there was a program that was run by the Greyhound bus company, and some of you who are old enough to remember this, I'd be happy if you confirm this, because other people have, called the $99 program, in which you could get a ticket for $99, so you could visit 99 places. Something like this. I might not have it exactly right. And so he took this giant bus tour from Pittsburgh all around the United States as a student. And somewhere in the west of Canada, he said to the Greyhound bus driver that he wondered if he would stop the bus for 10 minutes so he could do his prayers. And the bus driver said, well, I'll ask everybody. So he took a vote. And everybody on the bus agreed that they should stop the bus for 10 minutes so that Mahmoud Mamdani could say his prayers. And they all got out of the bus. Everybody got out of the bus, and they stood in a big circle around him. Whether that was to protect him or out of curiosity, he doesn't tell that story in his new book. But it's told very much as a story of this kind of benign American tolerance, a kind of benign American multiculturalism, if you like. And then they all got on the bus and went on their 99 tour stop of the US. I think that's a nice story.
So another question that we've touched upon, I think, and maybe this is complicated to answer, how do we actually determine what religion is in each country?
So in most countries, we have an office that decides that. That's how it's determined. The Office of Religious Affairs, or whatever it's called, every country except the US has one of these offices. They decide. And they decide in different ways, and you might not agree with what they decide, but you know what they've decided. It's official. We have no official definition of religion in the US at all. There is no official definition. This is hard for people outside the US to take in. When Europeans ask me what the definition of religion is in the US, I said, we don't have one. And they just think I'm joking. Like, how can you be a proper country and run yourself if you don't have a definition so that people know what you can do if you're a religion, whether you can have chaplains in jails, whether you can have halal food in the cafeteria in some government institution. There are all sorts of many ways in which religion can be helpfully regulated, not discriminated against, but helped to work if you have a government office that manages these things and defines them.
So Ben, in Canada, is there such a place?
No, actually there isn't. In Canada has also no single definition of religion, and the way that religion has come to be defined in Canada is actually subjectively in the person claiming the religious service or claiming the right. And so, in fact, the courts have stepped back and have, in fact, held that a feature of religious freedom in Canada is that what counts as religion is to be determined, in essence, within some very broad contours, in terms of subjective sincerity. If somebody subjectively, credibly, sincerely believes that a particular act or a particular behavior or a particular dimension of their lives is religious, then it is so, But of course, in Canada, that's also limited by the presence of limits on rights. And so it's a very different structure in Canada and how we think about things like rights. You can have a right which is abridged, but then can be justified because of public purposes, or it being what we call demonstrably justified in a free and democratic society. It can be essentially justified for its limits. But religion in Canada is also, at least at law, understood in a subjective fashion, no particular definition. And of course, that produces all kinds of effects. I think one point worth making about this is that, an impulse is to say that, well, that's good. That's the law stepping back from religion. But in fact, it's nothing of the sort. It's actually quite an intervention into the structure of religious communities. What it means is that rather than saying these official or formal features are what make religion religion, it makes religion a matter for the individual. And what that does is it empowers the individual within, at least can empower the individual within religious communities. This is another point about the necessary involvement of religion and law. It's another part of Winnie's impossibility thesis, that whatever choice you make when you're in a regime of the legal management of religion limits what counts as religion. Some get in, some get out. And so I think that's an interesting way of thinking about it, is that even a stepping back into subjective sincerity is a way of authorizing some religion and deauthorizing some.
And yet you do have still some features of establishment in the sense that you have, as you say, government-paid religious schools. So there is an explicit management and an interaction between the Canadian government and the Church of England and the Catholic Church.
Yeah, the question, it's another difference in the countries. The question of how money flows is just a total red herring in Canada. So state funds can flow to all sorts of organizations without abridging any sense of separation. We have religious hospitals that receive public funds. We have certainly certain religions that receive funding. Catholic schools in Ontario are an example. But these are particular arrangements with Catholic schools in Ontario and not a feature, in a sense, of a general disposition toward religion. It's not a question of defining religion. It's a question of a historical relationship, specifically with Catholicism.
This leads to another question, I think, which is about indigenous religions. So, of course, in each country we have a history and tradition of indigenous religions. There's histories of suppression. There's histories of simply not paying attention. I mean, so what can we learn about religious history in the U.S. and Canada based on the history of indigenous religions?
Well, I think it's been hinted before. One of the things we can learn is the inadequacy of the word religion to encompass. I mean, one of the ways, I think, in different ways, in both the US and Canada, religion can be a word that actually shrinks indigenous sovereignty. And so that one of the things that happened, maybe just to talk about the US for a minute, is that what you see is as various Native communities in the US are struggling for ways to recover their rights, they engage in treaty legislation. Of course, there's a sort of a whole range of legal strategies that different Native American groups in North America and also in Hawaii and in Alaska use to try to regain some rights that they have lost. During the 1970s, there was a period during which a group of various Native agents tried to argue that one one thing or another that was being done by the federal government was a violation of religious freedom, they mostly lost those cases because the federal government said, as they said in Boca Raton, that's not really religion, what you're talking about. And so I would say that the legal strategies for indigenous communities in this country have shifted towards assertions of sovereignty through treaty rights and other establishment of rights which are more holistic, which recognize, because in indigenous communities themselves, religion is not separated out. The separation out of religion as a feature somehow of Native communities is something that is external to them, and it does violation to the way in which they understand and imagine their communities to be governed. And so actually, the recognition of religious, of the religion of indigenous communities can sometimes, sort of in the short term, seem to accomplish one thing or another with regard to, for example, fishing rights or various kinds of land-based rights. But in the long term, it has a tendency actually to break up indigenous sovereignty and indigenous claims to governance that are more robust and that aren't separated in that way.
What about indigenous religions in Canada?
Yeah, it's such a great question, and it's such a deep part of the current kind of political culture and social culture in Canada. I think, let me say one about the history and one about this question of litigation, and then I'll tell you a story from a case in British Columbia on the west coast of Canada. So the history, Terry, that you asked about, thinking through that history, is one where the extension of the sovereignty of the Canadian state westward, but throughout Canada, was always mixed with the suppression of Indigenous religion, culture, spirituality. And so law and missionaries moved together across Canada in this colonial expansion. And we saw a number of features. The banning of certain kinds of cultural, religious, spiritual, and Winnie's pointed to the difficulty of breaking those apart. Ceremonies like the potlatch, like the Sundance, and most notably, the residential school system, which was run by the Catholic Church and Anglican Church, and what had as its object the extinguishment of Indigenous language, culture, religion, and this is, a great crime of Canadian colonialism. And reconciliation now between Indigenous communities and Canada is very palpable as a federal, as a national project. Has it been effective? No. There's still massive inequalities and problems in that. But I think it's really worth thinking about the ways in which religion and state sovereignty were tied together in the place of Indigenous peoples. It's like the authority of the Canadian state was not just about spreading law and institutions. It was also about consolidating the elements of sovereignty that were present in religion, right? And capturing those, in a sense, from Indigenous people. So the history there is extremely interesting, and I'll say importantly, not generally told as part of the history of religious freedom in Canada, and that's just effaced. It's covered. I think an interesting feature of the power of the category, if you're just interested in how much work in the modern state freedom of religion does, Canada has an explicit constitutional protection for Indigenous, Aboriginal Aboriginal rights and title over land and Aboriginal rights. And recently, there was a case at the Supreme Court of Canada in which, in essence, Indigenous community was so exhausted by the ineffectiveness of that particular provision targeted at questions of sovereignty and title, that they turned to freedom of religion as an alternative. It's as though the religion as a category could be more helpful on the sovereignty question at the heart of Indigenous justice than the provisions that were there to do that work. So it says a lot about how sovereignty is preserved, I think, in the category of religion. But here's the little story, and I won't go on too much longer, but it's a case in British Columbia, in a little town on Vancouver Island called Port Alberni. And there's a public school, and in the public school, local Indigenous nation is invited to come in and do a smudge, which is a ceremony involving sage burnt and spread over the room to cleanse, purify the room. It's there on the school's account to show Indigenous culture, to show Indigenous sovereignty and presence and history, and a hoop dance. And the hoop dance is done at an assembly, and there's a short prayer, Indigenous prayer, that's said at the beginning. And it's a public school. And Christian parent objects that this is an abridgment of their freedom of religion because the children are compelled to participate and be exposed to religious exercises in a public school. And it goes through the courts up to the BC Court of Appeal. In the end, the courts say there wasn't the right kind of coercion of the children, it was passive, it wasn't endorsed by the school, it was more by way of cultural exposure. But my point in kind of telling that story is just to show how deceptive, how misleading the question of, is this an abridgment of religious freedom is. Because of the presence of the right, the question becomes, is this an offense to the state's duty of neutrality in questions of religion? But of course, the question of the state's neutrality is precisely the wrong question, given the history of the state's treatment of Indigenous peoples. The idea that the state should be non-involved and even-handed in respect of Indigenous religion, Christianity, Judaism, Islam in schools imagines a kind of equal present that makes the state mapping back seem just, but it does no corrective justice. The history of the state radically suppressing Indigenous religion, turning to neutrality is like to flick on the light switch and relieve the state of the burdens of the repair of the history of how it established the nation. And that's the work that religion does. That's the work that freedom of religion does. It asks exactly the wrong kind of question when it comes to Indigenous justice. And so I hope that kind of surfaces a little bit of what I think Winnie and I are both pointing to.
Great. So we are at the end of our appointed hour, and I'm going to throw out the last question from the audience for all of us to think about. Is there an ideal system for law and religion to coexist? What does that look like? Thanks for being here. Thanks for your thoughts about this topic. Thanks to our wonderful guests for the great comparison they've been able to do about this today. Thank you so much.